Welcome to the Law Key podcast, where you can listen and review case digests and get practical tips on how to survive law school in the Philippines. Studying law can be very challenging, especially for working students, but with the right tools, the right habits, and the right support group, we can surely survive it. This is Kim, your host, and I hope you enjoy and learn something from this episode. Here we go!
Hi, so for today's episode, we will be discussing about the case of Joseph Estrada versus Sandiganbayan and people of the Philippines. So this is with the GR number 148560, decided on November 19, 2001. So this is actually a landmark case, and this is a case assailing the unconstitutionality of the law and an act defining and penalizing the crime of plunder. So the facts of the case are: Petitioner Joseph Estrada, the highest ranking official to be prosecuted under RA 7080, are an act defining and penalizing the crime of plunder as amended by RA 7659, contended that the said law is unconstitutional because of, first, it suffers from the vice of vagueness; second, it dispenses with a reasonable doubt standard in criminal prosecutions; third, it abolishes the element of mens rea or criminal intent in crimes already punished under the revised penal code. So specifically, the provisions of the Plunder Law claimed by petitioner to have transgressed constitutional boundaries are Section 1, Paragraph 2 and 4, which are, for Section 1, it says that ill-gotten wealth means any asset, property, business, enterprise, or material possession of any person within the purview of Section 2 hereof, acquired by him directly or indirectly through dummies, nominees, agents, subordinates, and or business associates by any combination of or series of the following means. So first, Section 2, specifically by receiving directly or indirectly any commission, gift, share, percentage, kickbacks, or any other form of pecuniary benefit from any person and or entity in connection with any government contract or project, or by reason of the office or position of the public office concerned. And paragraph 4, which states that by obtaining, receiving, or accepting directly or indirectly any shares of stocks, equity, or any other form of interest or participation, including the promise of future employment in any business enterprise or undertaking. Furthermore, Section 2 also defines, or Section 2, the definition of the crime of plunder and its penalties, also states that any public officer who by himself or in connivance with the members of his family, his relatives by affinity or consanguinity, business associates, subordinates, or other persons, amasses, accumulates, or acquires ill-gotten wealth through a combination or series of overt or criminal acts as described in Section 1 hereof in the aggregate amount or total value of at least 50 million pesos, shall be guilty of the crime of plunder and shall be punished by reclusion perpetua, death. So, these are the another section which is of the anti-plunder law, which is mentioned by the petitioner to have transgressed the fundamental right, is Section 4, the rule of evidence, which states that for purposes of establishing the crime of plunder, it shall not be necessary to prove each and every criminal act done by the accused in furtherance of a scheme or conspiracy to amass, accumulate, or acquire ill-gotten wealth, it being sufficient to establish beyond reasonable doubt a pattern of overt or criminal acts indicative of the overall unlawful scheme or conspiracy. So these are the sections of the law that are subject for unconstitutionality. So before we dive into the issues of this case, let's first tackle the information filed by the Sandiganbayan against petitioner, former President Joseph Estrada. So according to the information filed, the undersigned Ombudsman, Prosecutor, and OIC Director, EPIB, Office of the Ombudsman, hereby accuses former President of the Republic of the Philippines, Joseph Estrada, aka Asyong Salonga and aka Jose Velarde, together with Jose Jinggoy Estrada, Charlie Atong Ang, Edward Serapio, Yolanda T. Ricaforte, Alma Alfario, John Doe, aka Eleuterio Tan or Eleuterio Ramos Tan or Mr. Oy, Jane Doe, aka Delia Rajas, and John Does and Jane Does of the crime of plunder defined and penalized under RA number 7080 as amended by Section 12 of RA number 7659, committed as follows. So according to the information, it was said that the then President of the Republic of the Philippines, by himself and or in connivance or in conspiracy with his co-accused, who are members of his families, relatives by affinities or consanguinity, business associates, subordinates, and other persons, and by taking undue advantage of his official position, actually acquired a total of 4,097,804,173.17 acquired. He actually acquired that total amount of value and thereby unjustly enriching himself or themselves at the expense and to the damage of the Filipino people and the Republic of the Philippines through any or a combination or a series of overt or criminal acts or similar schemes or means. First, by receiving or collecting directly or indirectly on several instances money in the aggregate amount of 545 million pesos more or less from illegal gambling in the form of gift, share, percentage, kickback, or any other form of pecuniary benefit by himself and or in connection with the accused Charlie Atong Ang, Jose Jinggoy Estrada, Yolanda T. Ricaforte, and many more. Second, diverting, receiving, misappropriating, converting, or misusing directly or indirectly for his or their personal gain and benefit public funds in the amount of 130 million pesos. Second, Third, by directing, ordering, and compelling for his personal gain and benefit, the Government Service Insurance or GSIS to purchase 351,878,000 shares of stocks, more or less, and the SSS or Social Security System 329,855,000 shares of stocks, more or less, of the Bell Corporation in the amount of total of 1,102,165,607.50. And lastly, by unjustly enriching himself from commissions, gifts, shares, percentage, kickbacks, or any form of pecuniary benefits in connivance with John Does and Jane Does. So as mentioned earlier, those acts or series of acts or combination of acts mentioned in the information were actually mentioned in the Plunder Law, specifically at Section 1, Article or Paragraph 1, misappropriation, Paragraph 2, by receiving or indirectly any commission, gift, share, percentage, kickbacks, or any other form of pecuniary benefit, and 4, by receiving or accepting directly or indirectly any shares of stocks, equity, or any other form of interest participation, including the promise of future employment in any business, enterprise, or undertaking. So, according to the Sandiganbayan, former president and his co-accused were were guilty of the anti-plunder law because of the mentioned acts. So what are the issues for this case? So the first issue, which is whether or not the plunder law is unconstitutional for being vague. So this could cover the subject of statutory construction. The second issue would be whether or not the plunder law requires less evidence for proving the predicate crimes of plunder and therefore violates the rights of the accused of the due process. This is this issue could be under constitutional law or human rights. The third one is whether plunder as defined in RA 7080 is a malum prohibitum, and if so, whether it is within the power of Congress to classify it. So let's first tackle the first issue. So whether or not plunder law is unconstitutional for being vague. Now, according to the Supreme Court, the legal concepts pertaining to the validity of legislation is predicated on the basic principle that a legislative measure is presumed to be in harmony with the Constitution. So this strong predilection for constitutionality takes its bearings on the idea that it is forbidden for one branch of the government to encroach upon the duties and powers of another. Thus, it has been said that the presumption is based on the deference the judicial branch accords to its coordinate branch, the legislature. Hence, in determining whether the acts of the legislature are in tune with the fundamental law, courts should proceed with judicial restraint and act with caution and forbearance. So, the Supreme Court also said that where the law clearly and palpably transgresses the hallowed domain of the organic law, it must be struck down on the site, lest the positive commands of the fundamental law be unduly eroded. So according to the Supreme Court, the onerous task of rebutting the said presumption heavily weighs on the party alleging the validity of the statutes. In this case, it's the petitioner, former President Joseph Ejercito Estrada. He must demonstrate beyond any tinge of doubt that there is indeed an infringement of the Constitution. For absent such a showing, there can be no finding of unconstitutionality. Now, according to the Supreme Court, the petitioner in this case has miserably failed to discharge his burden and overcome the presumption of constitutionality of the plunder law. As it is written, the plunder law contains ascertainable standards and well-defined parameters which would enable the accused to determine the nature of his violation. Section 2 is sufficiently explicit in its description of the facts, conducts, and conditions required or forbidden, and prescribes the elements of the crimes with reasonably certainty and particularity. So thus, the elements of the crime of plunder according to this is first that the offender is a public officer who acts by himself or in connivance with the members of his family, relatives, by affinities or consanguinity, business associates, subordinates, or other persons. So remember, this was present in the alleged information filed by the Sandiganbayan. Second, that he amassed, accumulated, or acquired ill-gotten wealth through a combination or series of the following overt or criminal acts. So there are a lot, but one of them would be through misappropriation, conversion, misuse, or malversation of public funds by receiving directly or indirectly any commission, gift, share, percentage, kickback, or any other form of pecuniary benefits, by obtaining, receiving, or accepting directly or indirectly any share. So these all were present on the information filed by the Sandiganbayan. Lastly, the aggregate amount or total value of the ill-gotten wealth amassed or accumulated or acquired is at least 50 billion pesos, which is as well present in this case because according to the information filed by the Sandiganbayan, petitioner accumulated more than 4 billion pesos of ill-gotten wealth. Petitioner also argued that the failure of the law to provide for the statutory definition of the terms combination and series in the key phrase combination or series of overt or criminal acts found in Section 1 and Section 2 and the word pattern in Section 4, these omissions, according to petitioner, render the Plunder Law unconstitutional for being impermissibly vague and overbroad and deny him the right to be informed of the nature and cause of the accusation against him. Hence, is violative of his fundamental right to due process. However, the Supreme Court said that it's not a violative, the law was not vague, hence is not unconstitutional. According to the Supreme Court, a statute is not rendered uncertain and void merely because general terms are used therein or because of the employment of terms without defining them. Much less do we have to define every word we use. And besides, there is no positive, constitutional, or statutory command requiring the legislature to define each and every word in an enactment. Congress is not restricted in the form of expressions of its will, and its inability to so define the words employed in a statute will not necessarily result in the vagueness or ambiguity of the law so long as the legislative will is clear, or at least can be gathered from the whole act which is distinctly expressed in the Plunder Law. Moreover, the Supreme Court said that it is well-settled rule of legal hermeneutics that words of a statute will be interpreted in their natural, plain, and ordinary acceptation and signification unless it is evident that the legislature intended a technical or special legal meaning to those words. So the intention of the lawmakers to use statutory phraseology in such a manner is always presumed. Thus, in this case, the Webster's New Collegiate Dictionary contains the following commonly accepted definition of the words combination and series. So combination means the result or product of combining, the act or process of combining. Series, a number of things or events of the same class coming one after one another in spatial and temporal succession. According to the Supreme Court, the Congress intended the words combination and series to be understood in their popular meaning is pristinely evident from the legislative deliberations on the bill, which eventually became RA 7080. So in short, a statute that has words that are in general terms are not necessarily declared as void because it is a well-settled principle of legal hermeneutics that words of a statute will be interpreted in their natural, plain, and ordinary meaning unless there is an evidence that the legislature intended a technical or special legal meaning to those words. So in this case, it was proven that through the legislative deliberations on the bill, the Congress intended the words combination and series to be understood in their popular meanings. So when the Plunder Law speaks of combination, it is referring to at least two acts failing under different categories of enumeration provided. On the other hand, to constitute a series, there must be two or more overt or criminal acts falling under the same category of enumeration found in Section 1, Paragraph D. Let's say, for example, misappropriation, malversation, and raids of the public treasury, all of which under Section 1, Paragraph D. Now let's move on to the second issue, which is whether or not the Plunder Law requires less evidence for proving and for proving the predicate crimes of plunder and therefore violates the rights of the accused to due process. So on the second issue, petitioner advances the highly stretched theory that Section 4 of the Plunder Law circumvents the immutable obligation of the prosecution to prove beyond reasonable doubt that the predicate acts of constituting the crime of plunder when it requires only proof of a pattern of overt or criminal act showing unlawful scheme or conspiracy. So let's try to refresh what Section 4 say. So, rule of evidence: for purpose of establishing the crime of plunder, it shall not be necessary to prove each and every criminal act done by the accused in the furtherance of the scheme or conspiracy to amass, accumulate, or acquire ill-gotten wealth, it being sufficient to establish beyond reasonable doubt a pattern of overt or criminal acts indicative of the overall unlawful scheme or conspiracy. Now, according to the Supreme Court, in a criminal prosecution for plunder, as in all other crimes, the accused always has in his favor the presumption of innocence, which is guaranteed by the Bill of Rights. And unless the state succeeds in demonstrating by proof beyond reasonable doubt that culpability lies, the accused is entitled to an acquittal. So the use of the word reasonable doubt standard is indispensable to command the respect and confidence of the community in the application of the criminal law. So this reasonable doubt standard has acquired such exalted stature in the realm of constitutional law as it gives life to the due process clause, which protects the accused against conviction except upon proof beyond reasonable doubt of every fact necessary to constitute the crime with which he is charged. So in this case, the burden, so the standing of the court in the second issue was the burden still remains with the prosecution to prove beyond any iota of doubt every fact or element necessary to constitute the crime. So in the thesis that Section 4 does away with proof of each and every complaint of the crimes, suffers from a dismal misconception of the import of that provision. What the prosecution needs to prove beyond reasonable doubt is only a number of acts sufficient to form a combination or series which would constitute a pattern and involving an amount of at least $50 million or $50 billion. So, to illustrate, supposing that the accused is charged in an information for plunder with having committed 50 raids on the public treasury. So the prosecution need not to prove all these 50 raids, it being sufficient by pattern of at least 2 of the raids beyond reasonable doubt, provided only that they amounted at least to $50 billion. For example, so in this example, it says that, for example, this person was actually charged with plunder, for he has committed 50 raids on the public treasury, but the prosecution actually need not to prove all these 50 raids. It is already sufficient to prove at least 2 of them, for as long as those 2 actually constituted, or the total amount of ill-gotten wealth for those at least two raids will be at least $50 billion pesos. So in short, the Supreme Court said that the plunder law. So in short, the Supreme Court said that the plunder law is actually not violative of the fundamental right of the people, which is the due process clause, because because it will always be the burden of the prosecution to prove beyond reasonable doubt that the petitioner or that the accused has actually committed such crime. So the Supreme Court also reiterated that with in Section 4, what the prosecution actually needs to prove is beyond reasonable doubt is only a number of acts sufficient to form a combination or series or a pattern and involving an amount of 50 billion pesos. On the third issue, the petitioner actually contended that the statute eliminates the requirement of mens rea or criminal intent, and that is the reason why he claims the statute to be void. Now, the Supreme Court said that the petitioner actually cited the following remarks of Senator Tanyada as one of his proof that the said statute eliminates the requirement of mens rea. Now, the Supreme Court actually was saying, the Supreme Court actually said that Senator Tanyada on the said phrase was only saying that where the charge is conspiracy to commit plunder, the prosecution need not to prove each and every criminal act done to further the scheme or conspiracy, it being enough if it proves beyond reasonable doubt a pattern or overt or criminal acts indicative of the overall unlawful scheme or conspiracy. And as far as the acts constituting the patterns are concerned, however, the elements of crime must be proved and the requisite mens rea must be shown. Indeed, Section 2 provides that any person who participated with the said public officer in the commission of an offense contributing to the crime of plunder shall likewise be punished for such offense. In the imposition of penalties, the degree of participation and attendance of mitigating and extenuating circumstances as provided by the revised penal code shall be considered by the court. So the application of mitigating and extenuating circumstances in the revised penal code to prosecutions under the anti-plunder law indicates quite clearly that mens rea is an element of plunder, since the degree of responsibility of the offender is determined by his criminal intent. So that's the case of Estrada versus Tanyada, wherein the Supreme Court holds that RA 7080, otherwise known as the Plunder Law as amended by RA 7659, is constitutional. Consequently, the petition to declare the law unconstitutional is dismissed for lack of merit. So that's the decision of the Supreme Court for this case.
That's it for today's episode, guys. By the way, if you want to get a copy of the full text of the case, highlighting the important details I mentioned earlier, you may want to check this podcast description for the link. Thank you for listening and talk to you next time. Bye!